Okay, let's talk. Let's talk real quick about Ron. He made an
Um,
interesting tweet the other day. I assume you saw it. Uh,
yeah,
are you
it
okay? Do
was
you have COVID?
yeah, I've got COVID. At the coop.
I think I sent you the tweet.
You
Uh,
did.
and it
You
was a
did.
tweet disclosing some discussion about mediation, which, if I'm not mistaken, there's a Texas Rules of Civil Procedure
Yeah,
rule stating
yeah,
that mediation discussions are confidential. Can you
yeah.
talk about what that means?
Well, they're inadmissible. They're inadmissible, and God, I've never in 25 years, I've never had anybody publicly disclose what went on in mediation. So this is sort of new territory. But the deal about privileges is very simple, as you well know. A lot of things in the law are privileged, i.e., they can't be introduced as evidence.
Right.
And in some cases, they can be privileged for one purpose but not another, et cetera, et cetera. But one of the basic golden rules of privilege is a party waives privilege if they publicly talk about it.
Right. And they don't just waive
And
privilege to the specific statement that they make.
no,
They
no,
raise privilege, or they waive privilege for the subject matter.
no, this wife beating little gnome has has not
No.
only waived has not only waived privilege, in my opinion, for himself. I would argue he's probably waived it for all of his co-defendants. We're going to test it because I fully intend to notice the mediator for deposition.
Yeah,
That's going to be a
that's
great hearing. That's unprecedented. I've never heard of anybody doing such a thing. But the great thing about it is, I mean, literally anything in that mediation, I think, that deals with them is discoverable. I'm not going to comment on anything he said because I'm not going to waive the privilege.
right. That,
Okay.
well, see, that's the funny thing
And
is,
that'll be the remarkable thing. I mean, if it works, I'll be able to say, Mr. Mediator, what did Ron Toy say to you in the mediation? And if they ask the mediator the same question about me, I can object and say, Your Honor, that's privileged. And we haven't waived that privilege.
now
You know,
the funny
you know,
thing, you know, a bunch of people messaged me about this. Most of them like, "Did you see this? Did you see?" I got a bunch of those Twitter messages.
yeah.
But I also got some people saying, "Is this true?" And I had to respond back like, "I don't know, because it's privileged." And
And I will not comment on it because it's privileged.
and
You know,
there are people
that's,
who mistakenly think that because you and I have talked on these shows and stuff like that, that you actually disclose privileged things to me, which is obviously
no,
not true.
no.
It's almost like we're both lawyers who are professionals at keeping secrets when
Kind
necessary.
it kind of is like that, isn't it?
But it's but and these people mean well, right? Like they're like, "Oh, is this true?" And they just must assume that I know. But I don't. I actually don't know any of the offers or anything. And so it's like, I couldn't tell you. And more importantly, I don't want to know.
well, I wouldn't hesitate to call the other party, the other side out in a lawsuit if they were publicly lying about something. I normally wouldn't hesitate to call them a lying sack of shit. But I'm not going to do that in this case. I'm not going to comment on it because I don't want to waive the privilege. But I
Right.
do absolutely intend. Now, the judge may not, he may not buy it. He may shut us down. But we're going to certainly try. So I hope the wife beating little shit continues to babble and babble and babble. We're of course, we're archiving all that crap just like we did the previous one. So by all means, I hope he blows the interwebs up talking about this crap. But I would not be very happy with a client myself if they were out there waiving critical privilege, because the thing is, and I don't, and I really hadn't thought this through quite. I mean, I'm working it out in my head, and I got to call into a buddy who's a big legal ethics guru, so I'll get some input on that. But you know, there's a lot of attorney-client communication that goes on in a mediation. I think he may have waived that too. You know, I mean, this is so obviously, I guess they think they're going to win out, at the appeal. I mean, if to the extent that there's actually a strategy here, if you want to give him that kind
Yeah,
of credit.
I don't know if Ron is strategizing on anything. I know that I assume that they're all confident on the appeal because that's kind of how you go into appeal, especially if you won at the lower court, is you're going to be confident that the decision's going to be upheld.
Yeah, yeah.
And
Well, the thing is, the odds are with the non-appealing party. That's just the basic statistics. But I don't think they're that that's really a foolish high stakes game. And I doubt, it seems unlikely to me that anyone said, "Hey, let's do this. Let's waive privilege in the mediation." I doubt seriously that it ever occurred to him that he was doing that. But that doesn't matter. You don't get to say, "Well, I didn't mean to waive privilege." It doesn't work that way. So
right.
yes, I hope he continues to make all kinds of allegations about the goings on in the mediation, because that'll just make my life easier whenever I attempt to depose the mediator.
Yeah. So we'll see. Of course, the big hurdle
Well,
is the
and the thing is, anybody else that was in the room, the insurance adjuster, I mean,
right.
that's this gets, this is really stupid. I mean, by any objective standard. But the silence on our side is solely because we don't want to waive privilege, and it should only be interpreted as that. So
Yeah.
take that for what it.
Well,
But I appreciate the little gnome helping us out.
we'll have to see. We'll have to see. Of course, it all hinges really on appeal, and so I think you guys have a lot of reason to be hopeful on appeal, but I'm a pessimist in general, and so I'm trying not to like hype and get people's hopes up because appeals are uphill battles.
We truly don't know. There's, we've war gamed it, and we've got a spectrum of possibilities that go all the way from we get completely blanked to they get completely blanked. You can see a path to either of those outcomes and everything in the middle. So, we've taken the best shot we can take. We've done everything we can do. The Fort Worth Court of Appeals tends to not be particularly friendly to the TCPA, but that doesn't necessarily mean anything. The Chief Justice is she's a very thoughtful judge, and what I mean by that is I was familiar with her before this case ever came out. She had a blog that she talked about evidentiary issues that lawyers routinely get wrong, like hearsay. I became something of a hearsay guru because that was my job in trial advocacy and the mock trial competitions in law school. But lawyers routinely screw hearsay up, and she had a very, very good series. I think it's still out there. I'd recommend any lawyer to look it up. But other than that, I mean, we've certainly done about all we can do, and if I had to bet money, I would bet that it gets remanded back to the trial court. But
I think there's so many issues in it, and some of them just seem like the obvious move to resolve is to go and resolve issues, and that means that
I think
I'm hard pressed to think that nothing comes back, but it's
me too. But I think if I were the other side, it's easier for me if I try to put myself in the other side's shoes. If I were the other side, what would deeply trouble me would be the fact that I put all the evidence necessary to make a prima facie case in my filings, and unfortunately, Vic's attorneys called me out on that. Because if the court wanted to get rid of it in a hurry, they literally could say we're not even going to address the evidentiary issues with the plaintiff, because the defendant gave everything necessary to meet the prima facie burden of evidence. One thing that court does seem to, based on the previous TCPA cases, they do seem to understand what prima facie evidence is, and That's such an unfamiliar evidentiary standard to actually deal with in a courtroom. Trial judges almost never run into that. And so, you know, but you can tell from the appeals court that was the Khan case, one that we cited a lot. They got it. So, you know,
Yeah. Well,
we'll know
and
soon enough. They're taking it on submission, I think, the 22nd of this month. And I wouldn't think it'd take them that long to rule. They won't. I'm sure they won't rule on the 27th, 22nd. I would be surprised, but I don't think it'll take too long for them to rule after that.